U.S. District Judge Sherilyn Peace Garnett appears to be siding with Gina Carano and her lawyers against the Walt Disney Company and its lawyers in its motion to dismiss Gina Carano's lawsuit. If this is indeed the case, this is a huge win for Gina Carano and a massive, massive failure for the Walt Disney Company. And it's just the latest in a string of legal failures that the Walt Disney Company has been embroiled in. Before we get to this, I'd like to ask you, please hit that subscribe button, hit that bell for notifications so you don't miss any of our future videos here at the Trent Report. Roll this up over at thatparkplace.com. And just to kind of give you a refresher on the lawsuit that Gina Carano filed, she filed it back in February. And it detailed this. It is a civil action arising from defendant's wrongful termination of Carano's employment in retaliation for Carano's lawful exercise of her right to speak and express her views. Specifically, defendants, that's the Walt Disney Company, under the regime of former Disney CEO Bob Chapek, fired Carano because of her posts on various social media platforms, including X, formerly known as Twitter. Carano composed and published the posts while she was off duty and away from the workplace. The suit also alleged defendants terminated Carano's employment and took other retaliatory actions to limit and deny her future employment opportunities, including but not limited to making maliciously false statements about Carano with the intention of damaging her reputation and thus her ability to find and retain work. It also said this: defendants treated Carano differently than her similarly situated male coworkers, who likewise expressed their personal political views on social media, but upon information and belief were not counseled or disciplined, let alone terminated. They use Pedro Pascal as one of the examples, as well as Mark Hamill. The lawsuit specifically accused the Walt Disney and Lucasfilm of wrongful discharge and refusal to hire, and sex discrimination. In her lawsuit, Carano is asking for preliminary and permanent injunctive relief, requiring defendants to reinstate Carano to her position with no loss of pay or benefits, a judgment declaring that defendants' termination of Carano's employment was unlawful and in violation of California law, compensatory damages, including but not limited to loss of pay from the date of termination to the date of reinstatement, in an amount to be determined at trial, but exceeding $75,000. Compensatory damages for loss of future employment, including but not limited to the promised role in Rangers of the New Republic, in an amount to be determined at trial. Emotional distress damages in an amount to be determined at trial. Punitive damages in an amount to be determined at trial. Reasonable attorney's fees and costs, and such other and further relief as the court may deem just and proper. The Walt Disney Company filed a motion to dismiss this lawsuit in April, and the company argued that Disney makes this motion on the grounds that Disney has a constitutional right not to associate its artistic expression with Carano's speech, such that the First Amendment provides a complete defense to Carano's claims. Later in the motion, the company's lawyers argued that Carano's claims are all barred by the First Amendment. As the Supreme Court held in Hurley v. Irish American Gay, Lesbian, and Bisexual Group of Boston, the First Amendment embodies a core principle of speakers' autonomy that bars the state from dictating to expressive enterprises what to say, how to say it, and whom to say it through. Disney continued saying, as the court further held in Boy Scouts of America versus Dale, that principle means that a state cannot force an employer engaged in speech to speak through an employee whose own views or public profile could compromise the employer's own message, even if the employee does not express her views on the job. Disney's motion continued saying, the coup de grace came in February 2021 when Carano admittedly reposted on Instagram a post comparing criticism of politically conservative viewpoints to the Holocaust in Nazi Germany. Carano's decision to publicly trivialize the Holocaust by comparing criticism of political conservatives to the annihilation of millions of Jewish people, notably not thousands, was the final straw for Disney. As Carano alleges, Lucasfilm that same day denounced her statements and observed that it had no plans to employ her in the future. The motion later said Disney had enough. The same day Carano grotesquely trivialized the Holocaust as comparable to sharp political disagreements, Lucasfilm announced that Gina Carano is not currently employed by Lucasfilm and there are no plans for her to be in the future. Nevertheless, her social media posts denigrating people based on their cultural and religious identities are abhorrent and unacceptable. That was the statement, obviously, that a Lucasfilm spokesman issued to multiple press outlets. So on June 12th, Carano, her lawyers, and lawyers representing the Walt Disney Company appeared before U.S. District Judge Sherilyn Peace Garnett. And according to a report from The Hollywood Reporter, Judge Garnett was unconvinced by Disney's arguments. She said this: "I'm not convinced. There are no disputed facts." The outlet also reported that Judge Garnett appeared to favor an argument from Carano's lawyer, Gene Scher. Scher argued Disney's First Amendment defense cannot allow it to short circuit the normal litigation process. And according to the Hollywood Reporter, Judge Garnett reacted to this argument saying, "I don't necessarily disagree with you." So obviously not a lot to go on there, but it does indeed look like she is going to move forward with Carano's case and reject Disney's motion to dismiss. In fact, the Hollywood Reporter's Winston Cho shared his analysis, and he said this: "A federal judge has signaled that Gina Carano's lawsuit against Disney and Lucasfilm over her termination from The Mandalorian will be allowed to proceed as the court considers whether the First Amendment allows private companies to sever ties with employees who publicly clash with their values." As for Carano, this is kind of her reaction after she left the courtroom on Wednesday. She posted this to X, and she said, "In the beautiful halls of the federal court in Los Angeles, I was quite amazed at its splendor. I half expected to see Tom Cruise come sailing down the center like in the Mission Impossible movies. Having just left court, the judge said she would issue a ruling in the near future. This case is important beyond just me. Disney should not have carte blanche authority to fire any actor just because Disney disagrees with something they say outside of work. No actor would be free to have a voice if that were true. I look forward to this case moving forward and proving Disney's blatant discriminatory actions. Again, thank you for the support always." So she seemed pretty optimistic there. Obviously, not kind of commenting actually on what happened during the hearing, but just noting that the judge would issue a ruling in the near future. But she does appear to be very optimistic about her case moving forward. And I think that kind of echoes what we're seeing here from the Hollywood Reporter. We also have commentary from First Amendment lawyer Ron Coleman. He did an appearance on Valiant Renegade's YouTube channel, and he also appeared to be optimistic that the case would be moving forward. This is what he had to say as part of his analysis. He says, "The position Disney is taking right now, and what is probably offensive to this judge, as it should be, is do you own her? By virtue of having a job in one of your comic book movies," obviously in this case Star Wars, I wouldn't consider Star Wars really comic book. Obviously it's been adapted into comic books, but it was not originally comic books. It was inspired by serials. So I get where he's coming from there. "Is this woman now your property such that she can't express an opinion on any matter that you disagree with for as long as she's employed by you?" That's a very different proposition. So he thinks that the judge is seeing this and is kind of offended by it, and is one of the reasons why she will likely have discovery move forward. He later said this: "She's probably going to say there probably should be some discovery to find out, is that really why you fired her? Do you really believe, was there really some data that you relied on in making this significant, not earth-shattering, but significant creative and business decision to fire her, which said that her continued employment would turn off audiences? Or are you rationalizing that because what the emails and the texts and the Slack discussions will show is that you said this right-wing woman has got to go?" He then asserted, "Judge Garnett wants to hear more. I don't see how you come out of that hearing as Disney's lawyer with a great deal of optimism. The judge wants to hear more, and she wants to see some discovery." He then said this: "It's really, really important to understand that if she denies the motion to dismiss, it's not a ruling of the merits. It may very well be that Disney acted within its right in firing her. They may very well be based on a sober discussion of what they perceive their audience to be, or even a drunken and irrational discussion, but that it was really based on audience expectation and sensibility. But as I said, if they find that smoking gun that suggests that it was punishment for her not being on board with the woke agenda that is so baked into Disney as an institution, may very well make a big difference." So he reacted to these comments. He seems to think that the case is going forward. The Hollywood Reporter seems to think that the case is going forward. And if they get into discovery, this could be very, very, very bad for the Walt Disney Company, because I think there is going to be a lot of their dirt is going to get aired. Gina Carano has spoken about a lot of this stuff, but I think we're going to see the actual evidence of it, all the things that they tried to do to her, and how they maybe are potentially trying to control other people within the company. Because as Ron says here, Disney's argument is basically, do they own her? And that is quite offensive. And we'll see just how much maybe Disney does indeed try to own the people that they employ if it does indeed go to Discovery. So this is a huge, huge loss coming for Disney, it looks like. And it follows in the wake of a number of them. We just had reports that they basically gave up in their lawsuit against Ron DeSantis in the state of Florida. They had previously given up in the federal case against Florida as well. They've had to pay out, like, I think they made a deal with the state of Florida basically to like spend like $4 billion or something in investments. So Disney is losing and losing quite often when they are trying to make legal arguments. Because at the end of the day, I think, as Ron says, I didn't quote it in here, but he says it's Disney is just against the law. And, it's not that their lawyers aren't making convincing arguments. It's the fact that they're just operating against the law. But let me know what you guys make of this. What do you make of this hearing? Do you think that this case will be moving forward based on this report? And what do you think that Gina and her lawyers will discover if indeed it goes forward? Let me know in the comments below. Remember to always be charitable, especially to each other, but to always speak the truth.